So we've now discussed the Constitutional Convention and the structure of the government that was created there. We went through the structure and powers of Congress in a lot of detail. We went through the presidency and the powers associated with the presidency. Our next presentation is going to cover the federal court system and the powers held by our court system. First of all, the number of justices decided by Congress. First Supreme Court had 6 justices, and that was decided through the Judiciary Act of 1789, which we will mention again in a few minutes. Today's court has 9 justices. One of the justices is Chief Justice. The rest are known as Associate Justices. Now, one thing I'd like to point out is that the change made between 1789 and today should be noticeable, that you go from an even number to an odd number. And the reason they did that is so that there would never again be tie votes on the Supreme Court. The Constitution proclaims that all Supreme Court justices serve for life in good behavior. That means a justice can be impeached, just like the president can. Any public official can be impeached. The Judiciary Act of 1789 that I mentioned before organized all of the lower federal courts as well. The original system that was created had district courts for each state, and then 3 courts of appeals, one for the New England states, one for the middle states, and one for the southern states. As the country has grown, so have the number of district courts. In the year 2000, there were 94 district courts and 13 circuit courts. So that's more than one district court per state. States like New York have numerous district courts, especially in densely populated areas like New York City. And then the 13 circuit courts are strategically placed around the country to serve all of the regions of the country today. The appeals process. At the state level, you would have trial courts, probably even all the way down to the county level at that point, that would work their way through the state appeals court system, and then eventually, if need be, to the Supreme Court. At the federal level, you might have a case on appeal at the district court level, and then make its way up to the circuit court level, and eventually to the Supreme Court. So there are a couple different ways for a case to make it to the Supreme Court. Original and appellate jurisdiction. Original jurisdiction means that a lower court originally heard the case. Originally. So the very first time that a case is being heard by the court is original jurisdiction. Appellate jurisdiction belongs to higher courts that hear cases on appeal. Appellate, appeal. The words are very much the same. The only time the Supreme Court has original jurisdiction instead of hearing a case on appeal, so normally they have appellate jurisdiction. The only time they have original jurisdiction is when a case involves an ambassador or a dispute between 2 states. Those are the only 2 circumstances that the Supreme Court would have original jurisdiction. Now, one of the most epically important Supreme Court cases that you must know is Marbury v. Madison, and the language that is almost always utilized on the Regents exam is that Marbury v. Madison established the system of judicial review. And that is simply the Supreme Court's power to interpret the law and void it if necessary, declaring it unconstitutional. So just before leaving office, John Adams appointed William Marbury to a federal court judge position. The next president, Thomas Jefferson, ordered his Secretary of State, James Madison, to block the appointment. Marbury appealed all the way to the Supreme Court, saying that a 1789 law required Jefferson to carry out Adams' appointment. Now, Chief Justice John Marshall, the Marshall Court is a very significant period in history that we will get even more detail on moving forward in this presentation. He writes the majority opinion and said that the court decided that the 1789 law Marbury was using to argue his case was a violation of the principles of the Constitution or unconstitutional. The Marbury case establishes this principle of judicial review, as I already mentioned, and this allows the Supreme Court to overturn any unconstitutional federal or state law or action of government as well. Here's a political cartoon that is kind of comical. I wish for the power to declare laws unconstitutional. Why waste a wish on something you can grant yourself? Some people think that Marbury v. Madison and the establishment of judicial review was the judiciary giving themselves powers they did not in fact have. The Marshall Court also needed to clarify federal supremacy in the case McCulloch v. Maryland in 1819. The issue in this particular case was whether the state of Maryland was able to tax a bank chartered by the federal government, because the federal government is considered superior to the states in the Constitution. And Chief Justice John Marshall is quoted as having said, "The power to tax is the power to destroy," in his opinion that said, no, Maryland, due to federal supremacy, you cannot tax a national bank. So this case establishes the idea that any state law that contradicts a federal law is nullified or declared void because federal law is supreme. Now, this would only be the case when dealing with enumerated powers in the Constitution, and the reserved powers of the states would be still applicable through the 9th and 10th Amendments. You could see this political cartoon here, and it says, establishing a national bank was necessary to carry out Congress's power to tax. And the state of Maryland is saying, exactly, that's why we want it stopped. So really this comes down to they wanted to try to avoid paying their taxes. Here's another McCulloch v. Maryland. No state taxes on the banks. And this guy saying, give it up, McCulloch. Until the authorities come and say, sorry, sir, but you really can't make a state tax for a national bank. Oh, well, there it is right there in Article 1 of the Constitution. Guess I was wrong. And what he's referring to is the Federal Supremacy Clause. The last case we need to discuss is Gibbons v. Ogden in 1823. This is another clause in the Constitution that has to be clarified by the court, the Interstate Commerce Clause. The issue in this case was whether the state of New York was allowed to give only one steamship company the exclusive right to operate on an interstate waterway, the Hudson River. So a man named Ogden had been given the exclusive right by New York State. A man named Gibbons, who ran another shipping company, said, you can't do that. And it went all the way to the court, and the Marshall Court agreed with Gibbons and said, no, sorry, New York State, because the Hudson River services both New York State as well as the state of New Jersey, that makes it an interstate waterway. It makes it, therefore, fall under the federal government's right to regulate interstate commerce. It also clarified again the Supremacy Clause, because the Supremacy Clause applies, as I mentioned before, to enumerated powers, and the Interstate Commerce Clause enumerates a power for the federal government to regulate interstate commerce. So New York State was rejected in its ability to do this. Sorry for the blurriness of the cartoon. I did want to zoom it in, but it just isn't a very good quality. But get out! New York gave me the exclusive right to operate steamships in New York waters. Wrong. New York gave the United States the exclusive right to regulate interstate commerce. And that would be when New York ratified the Constitution that it gave that right. Now, the significance of the Marshall Court. John Marshall is a name that you gotta know. One of the most significant judicial figures in the history of the country. His court decisions are important for establishing the concepts of federal supremacy, which would include the McCulloch case and the Gibbons case, as well as judicial review, which is what makes the Marbury versus Madison case so very famous. That is it for this presentation. Thank you. See you in class.